Well, good afternoon, everyone. As Bruce said, my name is Quentin Cups. I am an attorney with the law firm of Vial, Fotheringham. We are an HOA attorney or law firm here in town that kind of a full service HOA law firm representing homeowners associations, condominium associations, and the like. I have been practicing law since 2006 and have been practicing in this area of law since late 2008 when I started doing this. So going into my 14th year of association law, and I enjoy it. It's it's interesting. You hear whenever associations come up, I think sometimes there's that negative connotation, and it sounds like maybe it's kind of a pigeonholed area of practice. But we actually get to review and discuss and analyze so many different issues and areas of the law. It keeps it entertaining. So I am the managing partner of this office in Arizona. Our firm has offices in many of the Western states, but we have 6 attorneys here in this office, and this is what we do. So I'm appreciative of the chance I get to present to you today, and thank you for all those who have joined us today. I think we probably all prefer to be in person, but I am grateful to technology that allows us to continue to do this. So I wanted to quickly here, I'm going to see if I can make this work. I wanted to launch a poll. I'm going to go ahead and launch this so you can see it. It's just a question. If we were in person, I'd ask this question to everyone. Just curious about who's in the audience and what your role is in the community in which you live. Are you just an owner? Are you a board member? Maybe you're a community manager. I think it's good, at least for me, to understand kind of where my audience is and the different perspectives that the audience members may have. So looks like we've got some answers coming in here. So it looks like 8 of the 12 are board members. We'll see 9 of 13 board members, got 3 homeowners and a community manager. So that's good. We got a good spread here. What I like to do, even though we're on Zoom, and as Bruce mentioned, it's not as maybe conducive to a discussion. I'm hopeful that we can still have that. If you're able to write, put in those questions, I'll try to keep monitoring that and try to answer your questions, and hopefully we can have a discussion that way. I don't know if you're able to. I don't think you're able to just chime in, but please send in the questions as you think of them, and I will try to get to them as we go through this. Let me see here. All right, so I already have one question. So Patricia, I will get to your question. I have it here, but I might answer this as we go through the presentation, but I'll make sure to look at that again. So today I was asked to present and suggested a topic that try to keep some relevant stuff in this industry, things that are happening. And there was that recent change in the law involving marijuana use in Arizona, and we actually were, as a firm, multiple clients did approach us around the time that this law was going into effect last year, asking about the impacts and what it would mean for the community. What can we do about it, if anything? What should we be concerned about? Those kind of things. So it is a question that's come up. I don't know. I'm assuming because you're here that it's a question you've thought of, and maybe it's something you're dealing with in your community. So I would like to go through this issue of marijuana smoking kind of in general, and what can an association do when it comes to this particular issue. So let's see if I can get this to work here. One second. I'm just going to figure out my technology here. There we go. All right. So we're going to cover, I am going to go into a little detail on the new law. You may all be familiar with this, but I think it's important to understand what the law allows and what it doesn't allow when it comes to marijuana use. And then we're going to talk about the responsibilities and options that the board and even community managers might have. And that will segue into just talking about possible revisions to your documents and some fair housing concerns that might come up. And then we'll have a question and answer period. And I'm happy to open that up to any question you have about this. And maybe you have other questions about other stuff. And I'm happy to try to answer those as well if time permits. I don't know how long this will last, presentation, but let's just jump into it here. So, all right. So the new marijuana laws last year, if you remember, Prop 207 was on the ballot. It passed. I think it was about a 60-40, somewhere around there, vote in favor of legalizing recreational use of marijuana. Let's see here. I'm just going to put up this slide for now. So as you think about this issue of marijuana usage, I think it's important that we first mention that under federal laws, it is still illegal to use and possess marijuana. This Controlled Substance Act, kind of the phrase that's used, is actually a list of all kinds of drugs and products that are prohibited to some extent, and they have different classes. And marijuana actually falls under a Class 1 controlled substance. And the classification that federal law gives is based on the kind of the addictiveness of it, the rate of continued use and addiction, availability, things like that. And it ranks right up at the top with some, I mean, Class 1 is the highest. So marijuana falls under that. But federal law still says that the usage of marijuana and possession is still illegal. And so we have to keep that in mind as we're having this discussion, because you do have the federal law that under the supremacy clause of the Constitution would still trump in a lot of areas and could still control. But then you have a number of states. I think we're up to, I think last I read, it's in the 20s, the number of states that have legalized recreational use of marijuana. And I think that number will probably continue to go up each year that it's presented on the ballots. So the Smart and Safe Arizona Act was the name given for Proposition 207. I believe, I don't know if Terry was able to put this on here. There's a handout that I had. It was actually a chart that I didn't create the chart. I'm not going to take credit for it. There's a chart I found that actually gives a really good summary of this law and the provisions of this law, in case you're curious. I think we tried to make that available to everyone. I don't know if
Quentin,
yeah.
Bruce went ahead and emailed that to all the attendees.
Oh, okay, good. So just check your email. You'll see, I think we sent you a copy of this presentation in a PDF format. And there's also this chart that like I said, it's titled the Proposition 207 Informational and Sentencing Chart. I'm not so worried about the sentencing because we're not in the business of arresting people and sentencing people. But it does give you an idea of what the law allows and what it doesn't allow. And so now in Arizona, under this proposition, anyone who's, and it first starts with the age. So anyone that's 21 years of age or older, it is now lawful to possess, consume, purchase 1 ounce or less of marijuana. That is now legal. It is also legal for anyone 21 years of age or older to possess, transport, or cultivate 6 marijuana plants for personal use at their primary residence. Now, what you can't do, I mean, while you can use this for your personal use, you can cultivate these plants for your personal use, it is still illegal to sell that to someone else for a profit. You can give it to someone else, but you can't sell it. And that's where you see that if you're looking at the chart, you'll see that in the transfer section that it is legal to transfer 1 ounce or less of marijuana to anyone who's 21 years of age or older, as long as there's no public advertisement of it and there's no remuneration or payment for that good or for that material. And you can also transfer marijuana plants as well, as long as there's no advertisement or payment. And then it's also legal to assist someone that's 21 years of age or older in those activities. Now, if you're under 21, everything I just said is illegal. and it comes with certain penalties. They're treated now, though, some of these initial penalties as petty offenses. So I don't know that there's a lot of punishment behind it for initial offenses, but anyone who's 21 and older, or anyone under 21, is not permitted to do this. Now, it is important to still mention, though, that anyone of any age, it is still illegal to possess greater than an ounce of marijuana. It's still illegal to smoke marijuana in all public or places or open spaces. And then you still would have to have a license to do anything that's in public view. Cultivating plants that are in public view, you'd still have to have that license. Now, what's important from this law is that this deals with the public space, and at least as far as you can't smoke or do anything in the public space. And then it also talks about activity in your personal residence for this recreational use. But it is very clear that there's nothing that would prevent someone who owns private property from doing something that might be different, from making this sort of activity illegal, or prohibiting that type of activity that could otherwise be done somewhere else. So that's kind of where the association comes into this. So just look at my notes here. I did find, and this was there's an ordinance, a City of Scottsdale ordinance 4484 that I have referenced there. That was, I think it was signed in right around the same time this law went into place. I'm just looking at my other screen here. But essentially, what that ordinance does, it's consistent with this new law, but it just makes it very clear that there is no use to smoking of marijuana on property that's owned by the City of Scottsdale, public streets, parks, things like that. So smoking of marijuana is going to be prohibited all throughout Scottsdale in those areas. So it's consistent with what Proposition 207 says, that as I mentioned, that proposition still prohibits that type of activity in the public space and the City of Scottsdale. And they also have added some other restrictions about operating vehicles, boats, and the use of marijuana when doing that is illegal under that ordinance. So now, with that said, and kind of with that understanding that now owners are, as long as they're not doing it in public, they've got their personal residence. You're going to have, you can have owners that are using all types of forms of marijuana, and potentially even growing marijuana in their house, in their unit, so long as it's not visible for the public. So, it's just not working here. So how does that impact the association? I think I don't know if those who are on the call, if you've dealt with smoking in the past, or other types of fumes or odors or things like that you may have had to work with, but you could have a situation now where you start getting complaints from neighbors, from other homeowners, that someone's smoking marijuana next door, or the smell is coming into my unit. I will say kind of upfront here that I think this issue is probably more prevalent in the condominiums in the valley. While we're still going to talk about what planned communities can do in single family homes, I think the bigger issue is going to be in the more of the close setting of a condominium, where they're sharing walls, maybe on top of each other, kind of the high rise kind of condominium, where the smell could be trapped, inside the building. But I want to talk about, these options that an association might have in dealing with this. So, as you all probably know, you as board members, for the ones that are board members are on the call, the handful of homeowners that are on the call, whenever we talk about association rights and responsibilities, we have to look at different sources of law. You have the statutes, which we've just talked about, the one law that's in place now regarding this use of marijuana. That's one source of law that you turn to. The other source of law would be our governing documents, and that's well, let me go back to, there's a good question here. So the question is, 6 plants would be more than 1 ounce. Is that a conflict? You know, that's a question from David. David, that's a great question. I don't know that I have an answer for you on that. I know what the statute says, and it might be a conflict. Again, it says 1 ounce or less of marijuana, no more than 5 grams of which can be a marijuana concentrate, or up to 6 plants for personal use. That's a great question, and I think maybe there could be a conflict there. Part of the problem with this topic is that, at least as associations are concerned, is, you know, what can an association do to really even enforce that? If it was a conflict, that might be something for, you know, that law enforcement would have to sort out. For us, maybe if we're talking about, you know, is it a violation of the law, therefore a violation of the documents, maybe that's something that could be used if we do know that it's more than 1 ounce. But I mean, it's a good question. I don't know that I have a better answer for you. It does, as you read it, it does sound like it could be a conflict, but that's the way it was written. That you could have either one or both. So that's all I could give you for that one on that question. So, but when we're talking about the source of the law that I was mentioning, the governing documents is the important one. You know, like I said, we have the statute, but we need to look at our governing documents. And because the governing documents are the source, the true source of the authority that the association is going to have versus the association that owners will have, you know, the rights that they have to use certain areas of the community or to do certain things within the confines of their home, within the confines of the common areas. Throughout the community, the common elements, that's going to dictate what, if anything, can be done if this issue comes up in your community. The CC&Rs have, well, and with this particular topic, you know, you might have some questions. Some of the questions may be tough to answer without me seeing what your documents say. And I think I have to preface that, you know, there are general questions that can be answered. More specific questions, it might be tough without looking at what your governing documents state and the different provisions. But most CC&Rs, I want to start kind of generally here. Most CC&Rs will have a provision towards the beginning that talks about the rights of the owners to use common area or to use the common elements. And then what it will also say, subject to the association's right to impose rules or restrictions on those areas. So that's one thing to keep in mind. You're also going to have a section probably right after that are your use restrictions. All the things that as homeowners you are not allowed to do in your community or on your property. You know, basketball hoops, running a business out of your home. I mean, there's dozens and dozens of use restrictions that you can think of. But one of those use restrictions might have something to do with smoking, or probably more common, more prevalent, is going to be the use restriction that prohibits owners from doing anything unlawful or from doing anything that would cause some sort of an odor, unreasonable smell, unreasonable noise that would harass neighboring homeowners or would be a nuisance to neighboring homeowners. And that's the one that I think most documents will have, and that's the one that a lot of communities will try to rely on in enforcing something like this or anything else that might be considered a nuisance. That's the language they may turn to try to prohibit something like this. So you have those rights. Now, not to get too far off on a tangent here, but I do want to make one comment about rules. One of the more common issues that I see in associations that I represent, as issues come on my desk, it is common for that issue to involve the board's abuse of the rulemaking authority. It's a problem that I've seen throughout the valley and throughout the state, quite frankly, where boards will get carried away with creating rules and writing in rules that they think are appropriate, and when in many cases it should be an amendment to your CC&Rs. So when it comes to rules, just keep in mind, and I'm sure all of you know this, but keep in mind a couple things. One, you can only create rules based on the authority that you are given as a board under the CC&Rs. So you need to look at that rulemaking authority language you have in your CC&Rs and look to see what it says. It will say, you have the right to create rules. So it'll talk about authority to create the rules in the first place. You look for that. Usually right after that is the scope. What is the scope of our rulemaking authority as a board? How broad can these rules be? Are we authorized to create rules for the entire property, which, the capital P property, the whole community? Or is our authorization for rules limited to just the common areas or the common elements, meaning that we can't touch the units or the lots with our rules? Probably 5, 6, 7 times recently, as we bring on a new community to represent, I'll look at their governing documents and they'll send me their rules, they'll send me their CC&Rs, and I'll look at it and I'll see that the CC&R rules say you can create rules for the common area, and that's it. And then I look at the rules and they have 40 different rules that govern the lots and the homes on the lots and the owner's activity on their lots, and they didn't have the authority to do that. So it's just a good practice tip if you're on the board, or if you're a homeowner and you're looking at your rules, is to look at what authority you have to create those rules and how broad can they be. And I mention that because of that application to this particular topic and how it could be applied. That's another, as we're looking at our source of law, the governing documents, you could also look to that rulemaking authority to see what's in there as a possible solution to this issue. So just look at here. Okay, let me go back a slide just real quick. One other thing I'll mention here is has to do with the enforcement, the right, the obligation, whatever rights you have as an association to enforce your documents. There is a when we're dealing with enforcement language, and you usually see this towards the end of your CC&Rs in the general provisions, or you might have a separate section titled enforcement. This is another part of your CC&Rs that if you're on the board especially, you should be very familiar with, and be very familiar and understand what it is that you have the right to do, and more importantly, whether or not you are obligated as an association to enforce your documents. I've seen 2 or 3 different variations of this. One will say that the association shall enforce the provisions of its governing documents. The other provision will say the association shall have the right to enforce. And another provision might say the association has the right or that has the duty and obligation. All of those have separate meanings, and it's important to understand the difference, because if it says that you have the obligation to enforce or you shall enforce, you don't have a choice. If something comes up, the association has to take some sort of action to try to enforce it. But if you have the right to enforce, or you may enforce, that's where the discretion kicks in, and the board can look at the situation, analyze it, decide, hey, what is it that we're going to do with this, if anything? Is it in the association's best interest for us to enforce this violation of the documents? Or is it in the association's best interest to maybe create new rules or take new action to try to address this problem? So I think it's important, kind of as a base, as a foundation to understanding how do we address this issue, is to have a good grasp on what are the rights that we have as an association or as owners when it comes to just general enforcement or general rulemaking. And then once you have that understanding, you'll know what your options are, and then you can make a decision on how you go forward from there. So hopefully that makes sense, and I felt that that's all relevant to what we're talking about, so that's why I wanted to bring it up. But with that said, I do want to touch on this next section here. Okay, this is, as I mentioned before, whenever you're dealing with unwanted noise, unwanted smells, unwanted activity, a lot of the CC&Rs that are out there, as you're probably familiar with, you can't possibly draft a set of CC&Rs that's going to contemplate and address every situation that comes up in a community or could come up. And especially if your documents are from the 70s, 80s, maybe the 60s or earlier. You know, back then, I was born in 78, so I can't even relate to some of those documents, but they certainly weren't thinking of some of the things that are happening now. And things evolve, things change. And so that's why you sometimes have these more general provisions like your nuisance provision that says that it is against the CC&Rs to conduct any activity that would be a nuisance to surrounding homeowners or to the association. And so that this is a common provision that associations will turn to, or homeowners will turn to when they'll fire off a complaint to the board to say, hey, my neighbor's doing X, Y, and Z. You need to enforce the CC&Rs and address this. So just once, I'm just looking at a question here. So it says, if I understand correctly, the statute does not allow smoking or growing in view of the public. That's correct. If an owner grows 6 large plants in their patio area, which can be seen and smelled by other owners in the community, that would be in violation of the law. I would agree with you there. Yeah, it can't be in view of the public. So now that could bring up the common definition you see in your documents of not visible from neighboring property. So if you're standing at a wall 6 feet tall, can you see what's going on the other side of the wall? But it may be a situation where you could see it in other ways that aren't unreasonable. But again, as an association, you know, if this is going on, what can we do? I mean, we're not law enforcement, and so it does bring up: is there something in our documents that would be in violation based on this activity we've observed that is a violation of the statute? So that's just. And then I have another question here about smoking in the common areas, and we're going to get to that here. So let me just keep going back with this nuisance thing here. And I think I'm going to answer these other questions as we talk about this. So, so when we talk about nuisance, I want to make sure, and this, I don't want to get too deep into the legalese and the case law on something like this, but I think it's important because like I said, this is a common provision that associations will try to use to enforce all kinds of things. But I think this is also a provision that boards get a little carried away with. And if push ever came to shove and you had to actually litigate the issue, I think more often than not, the issue that is being complained about wouldn't actually rise to the level of a nuisance that would be actionable in court. You know, you can go through the process of your notices and warnings and threats. But if it went any further, I think a lot of what associations complain about doesn't quite meet the requirement of what a nuisance is. So let me go through. I just have some notes. That's why I'm kind of looking down here. I want to make sure I get this right. If you search any case law in Arizona, There are some cases that have addressed a nuisance. There's a discussion about a public nuisance versus a private nuisance. A public nuisance is more of like what it sounds like, that it's an activity that's going to affect the public in general, whereas the private nuisance is more of the one-on-one situation, a neighbor, or in the association setting, I think it would fall under a private nuisance, where even if it's multiple owners that are affected by the activity, it's still localized into this area of the association, so it may not be a public. But either one, it's a very similar analysis. And so a nuisance has been defined a couple different ways, but a nuisance is a condition which represents an unreasonable interference with another person's use and enjoyment of his property and causes damages. Okay, so there's multiple parts there. You got to look at the unreasonable interference. What does that mean? It's interference with another person's use and enjoyment of their property. And then you have the damage component. How are you damaged by what's going on? If you're just annoyed by it, okay, that's probably not a damage that would be actionable. And unreasonable interference, if it happens one time, is that unreasonable interference? Probably not. And so then if some of you may be familiar with the restatements of law, and there's a restatement that talks about nuisances, and there's some comments here, and it says, to constitute a nuisance, the complained of interference must be substantial, intentional, and unreasonable under the circumstances. And then it goes on to say that it must constitute more than slight inconvenience or petty annoyance. The law does not concern itself with trifles, and therefore there must be a real and appreciable invasion of the plaintiff's interests. And then it also says nuisance ordinarily implies a continuity or recurrence of action over a substantial period of time. So I think we have to keep that definition, those comments in mind when we start thinking of does a nuisance exist on our property, and in the realm of marijuana or smoke, is it something that rises to that level of an annoyance? And I think it could be, but again, it's just going to depend on the situation. Now, if you look at the condominium setting, for example, where you have enclosed space, shared ventilation, a situation where someone's smoking below the unit, the above unit may be taking in that fume through the walls or through the ventilation, and it happens on a consistent basis over and over. Then you start thinking of going back to think about what is a nuisance. Well, okay, this happens over, it's not just once, it happens over a substantial period of time. It's a real and appreciable invasion of the plaintiff's interest, because how can someone live in their unit if that smell is constantly coming in, and it could be substantial. So I think it could, depending on if the facts are right, it could be a situation where it does rise to the level of a nuisance. I think associations, though, have to keep in mind that if they're approached by a homeowner who's complaining about the situation, and the associations decided, the boards decided, hey, we need to look into this, we need to take action. These types of claims are very fact sensitive, fact intensive. It really just depends on the facts of the case. It's not a one size fits all kind of thing, where you could just say, hey, I don't like the smell of marijuana smoke. I don't like the smell of cigarette smoke or whatever it is, therefore it's a nuisance. You can't always just make that leap and that jump to a nuisance. So I bring this up because this is probably going to be the most common provision in your CC&Rs that communities could look to try and enforce this issue of marijuana usage. I also want to say something else, though, that about when it comes to marijuana usage, there's all different types of forms of marijuana. I personally have not partaken in any of that, but I do know that it comes in, there's the edible form, there's smoking, there's, well, whatever else there is, there's different ways to do it. And I think there are different results. Obviously, there's different impacts that can be felt from the different use of marijuana. I think the smoking, that I think is going to be the most problematic because of the smell, because of the invasiveness of the smoke, the harm of secondhand smoke. I know there have been all kinds of studies, obviously, on the impacts of cigarettes and cigars and the tobacco secondhand smoke. In preparing for this, I was able to read quite a number of articles of just recent studies that are showing the real negative impacts of secondhand smoke from marijuana. That it has some of the same harmful chemicals that are found in cigarettes are also present in the marijuana, in smoking of marijuana. You have the addictive properties and the THC, and so they are finding real negative effects on smoking, which I think just goes to bolster any association's argument of trying to regulate this type of activity, just as you might try to regulate smoking. Is that there's the potential for harm to other homeowners, might help this rise to the level where we have to enforce it and we have to do something about it. And courts will kind of look at that balancing test, when they're looking at this type of issue of balancing the harm. So I don't know if there are any more questions about nuisance. I will say one other thing about a nuisance is that there was a case. There's actually a case that I reviewed in law school years ago. I went to law school in Ohio, and I didn't realize it was I kind of forgot it was an Arizona case, but it was a Del Webb. The Del Webb community is the developer. This was back in maybe the 60s. I can't remember, but they were trying to develop a community on the west side of the valley, and there was a large farm out there, a large dairy farm, and that had been there for many, many years. And they bought property next to it and then proceeded to complain about the smell. And they knew, the court ruled against the developer, saying, hey, you came into this nuisance. You knew that that nuisance was there. And so we're not going to give you the relief that you want. So that's something else to keep in mind with nuisances. If it's something that's present, and I mentioned that if that could come up with if a community has never done anything in the past to try to regulate smoking in the community, and then now all of a sudden wants to try to regulate it through some stuff we're going to talk about in a minute, that could be an argument that, hey, this has been going on, especially if there's evidence to show that smoking's been going on for a long time. Nothing's really changed. It's not like this is a new nuisance that all of a sudden you're aware of. So that's something to keep in mind there. So that's the nuisance provision. Well, if you don't have the facts to bring a claim for a nuisance, if it doesn't rise to that level of a nuisance that we talked about, that's kind of that prevalent existence, it's going on all the time, then you may, as an association, that doesn't mean you can't do anything. You may just have to look at other options. I also tell you that if you look up these types of cases across the country, there's not a lot of litigated cases over this issue of smoking and marijuana smoke. There are some, and I think there's a couple cases I'll want to bring up in this presentation, but it's not a common issue that has been litigated over the years, which I was hoping it had been, just to give some more stories to talk about. But some of the cases that I did find, they're kind of all over the map. Some states have found and held that secondhand smoke kind of on its face is a nuisance. There's some states that have gone the other way. There was a case in Maryland that found that secondhand smoke wasn't a nuisance, but in California, I think they even have statutes now in California that talk about that being a nuisance. I think in Utah they have that similar type of law that secondhand smoke is a nuisance. So we don't have that in Arizona, and I couldn't find any cases that were right on point with what we were talking about. But that's why I was giving you some of that other case law about the definition of a nuisance and what that meant. So I think it just kind of conclude on that it's kind of remains to be seen. How a court would ultimately handle that if it ever went that far in court. So, Okay, so here's a good question. So it says, what is different with marijuana? From an HOA standpoint, I don't see any difference between it and tobacco smoking, alcohol drinking that might disturb another homeowner. Seems like most of this has already or should have been worked out in existing case law in the CCNRs. Well, I would kind of agree with that it doesn't bring it's just a new element to consider. You know, in the past, marijuana is something that was illegal and really wasn't in the communities. Now it is, and it's just one other thing that associations are probably going to have to deal with, and complaints from homeowners about the smell, about the presence of it. You know, maybe there's the concern now that you know, maybe crime going up or traffic. It's just something else to keep in mind. And then I think the purpose of this topic was, while some of this may just be repetitive for some of you because of these other issues like smoking in general, I think it's important to know that the association does have those similar types of rights as you would with other matters. And if it's something that's already being handled in your CCNRs, then that's great. Then you should be able to control this and keep this in check, and it shouldn't be a real big impact in your community. I just know that there are a lot of communities that haven't been able to do much about smoking or haven't done anything about it, and now you introduce the marijuana on top of it, and the questions have started to come up of what can we do about it. So with that said, I want to talk about some of the options, and this will probably get into some of the questions that I think some of you have asked. If I go back and look here. So one of the questions, I know you can smoke on your own property, but how about in the common area? What can we do about that? And that's one question. And then there was also a question about a person lives in a co-op. They had no restrictions about smoking in our own enclosed patio. Now they're trying to pass where they want members to smoke in ramadas or areas. So those kind of similar questions there. So let me see if I can address both of those as we talk about this. As I mentioned before, when you look at your CCNRs, almost every set I have seen, if you're a planned community with single family homes with common area that the association owns, the association is going to have the ultimate say. It's their property. It belongs to the association. They will have the ultimate say in what can and cannot take place on that property. So if you want to ban certain activity on the common area, you have the right to do that, and homeowners will have to abide by that. So if you want to put in place, make it clear that marijuana usage, possessing it, anything like that on common area is prohibited, then you should, and make that clear, and just add that to the list of rules that apply to the common area. And again, as I said, it's the association's property. You can do that. The same probably applies to condominiums in the common elements that the association maintains and controls. Now, while the association doesn't own the common elements in a condominium, you still have the right to impose rules. And almost every document I've seen will say that at a minimum in a condominium, you can impose rules that will dictate what can take place on that common property. And so for marijuana or any other types of smoking, you could have those rules in place on the common elements or other types of rules, as long as you have that authority. The real question that comes up, though, is what, if anything, can be done about someone smoking in their own unit, someone smoking on their patio, their balcony, or some other area on their property. You know, can we do anything about that? And again, that's all going to depend on what your documents say. If your documents are silent on that, we'll talk a little bit about can we do anything to ban all forms of smoking in the community. To do that, if your documents are silent, I'm going to say that you're probably going to need to look at amending your CCNRs. You might have the ability to pass a rule that governs all the property, and you might be able to rely on that. It would be better if it came in the form of a CCNR amendment. But I want to talk a little bit about CCNR amendments. I'm sure all of you that have come into these classes and been involved in your associations know that a CCNR amendment is very tough. And even if you can amend your CCNRs, I mean, even if you have that authority, you know, the chances of getting, well, let's say even if you could get the percentage, let's say that you need 2/3 of your owners to sign off on it. Okay, there are some other legal arguments out there that might even prohibit the amendment with 2/3 and may require you to get 100%. So let me give you an example. In a condominium setting, there's a ARS 33-1227 is a statute that says that if you make an amendment to your CCNRs that affects the way in which a unit can be used, it will require 100% of your owners. And so this comes up all the time in a short-term rental setting that we want to prohibit short-term rentals. Well, that's going to trigger that statute in a condominium every time. If you try to ban smoking inside the unit through an amendment, you're going to trigger that requirement in a condominium. That's going to you're going to have to get all your owners to sign off on that to amend your CCNRs. So amendments may be an option, but it may be an impossible hill to climb to try to do that. So now you can look to your rules and see if you have the authority under your rules. And again, it all comes down to that authority and how broad can those rules be. But also keep in mind that rules have to be reasonable. And those of you who have been doing this long enough or been involved long enough probably know that I can't give you a great definition of what reasonable means. Sometimes I'll say it's the woman or the man in the black robe behind the bench that's going to tell me what reasonable is. I wish I had a better definition for you, but I think one thing you can look at is that if you have a community that's been around for some time and there's never been any effort to control smoking in the units or on the balconies, and then all of a sudden you come in with a rule saying you can no longer do that, I think there's a pretty decent argument that a rule like that may not be enforceable. So you may have to limit that rule. Again, like I said, you can control what's on the common elements or in the common areas. And even the limited common elements in condominiums, like your patios and your balconies, you probably have a pretty good argument that you can limit those as well and would have to force people inside if they want to smoke. But when you start getting into the units, it could be troublesome for communities to be able to do that with their rules. So, I bring that up because, while I wish there was a great solution to the issue of smoking or marijuana, unfortunately, there may not be the perfect solution, and associations may be faced with challenges or hurdles that they can't overcome. But if you have the ability and you want to explore that, I've put on the chart here on the page and on the next page some things that an association could consider doing through the amendment process or through the rulemaking process to try to address these different types of activity, whether it's banning all forms of cannabis altogether or certain types of cannabis use, maybe the growth of marijuana. Again, while you have a statute that says that type of stuff is legal, governing documents can be more strict than what the law says and could say something different. And people are bound by what the documents say. When you buy into a community, you have to abide by what the documents say. And as long as they are done correctly, as long as they have the authority to do that, I think there's, an argument that they get to say what you can and can't do, and you have to abide by that as a homeowner, even though the law might say something different. So you might be able to do that, create some rules that ban that type of activity. There's also the issue of the sale of marijuana, which that brings in a whole nother issue of, it's illegal to sell this type of recreational use marijuana. So that could trigger another provision in your CCNRs about unlawful activity. And maybe you don't have that provision in your CCNRs right now where it's unlawful activity is prohibited. So that could be something else that you look to if you are going to maybe look at amending, that you would want to put that in to prohibit unlawful activity. Now that's not going to cover all of what we're talking about, because that's going to actually create an interesting situation where you have, it's legal to do certain things under state law. It's illegal to do it under federal law. And I read a case actually, this is actually before Proposition 207 came out. Or no, it was right on the time. I think it was right on the time, because the issue was it was a landlord-tenant issue, and the court looked at which law controls, the federal law versus the state law, and came out in favor of the federal law, with a discussion about the Constitution, the Supremacy Clause, that federal law trumps, and said that was a violation of that rule, that it was a violation of the law is a violation of a breach of the lease. So that you might have an argument there as an association that it's still illegal under federal law to do any of this stuff. So you might be able to rely on that provision of your documents. So there are different ways you could address this as an association. I would recommend that if you are interested as an association in trying to address this activity, if maybe you don't have stuff already and you want to look at it, you certainly want to get your attorney involved to make sure that your rules or your amendments comply with the law and the procedures, the requirements. And don't try to do it on your own, because you certainly don't want to go down that road of getting it wrong if you were to try to implement those changes. One thing that I have seen, though, that I wanted to address that has come up with marijuana usage, and I think will become more prevalent for associations, and this is going to be different from, I think, just the general cigarette smoking restrictions that maybe we're trying to enforce against. Is, I think there are, because I've seen cases already where people are making claims for protection under the fair housing laws. And I know this isn't a fair housing class, and we could talk for multiple hours about fair housing, but I think it's important that we go through a little bit of the fair housing analysis. You may be seeing this, there's been a rise, at least that I've seen in our practice, on fair housing claims. Now, not specific to marijuana, but just fair housing in general. So here's a question. Can an HOA ban growing plants through rules and regulations? HOA pays for all water, and growing plants will increase water usage. I think the answer to that is yes. I think I appreciate the question, Nancy, because I had that in my notes to mention, and I just kind of went past it. When you're looking at in a community where the association does take or is responsible for the water, pays for the water through assessments, pays through the utilities, you have the issue of growing plants, which would use quite a bit of electricity for the lighting, and then the water usage. You're going to see an increase in that, and so I think that would go to the argument as to why the rule is reasonable, right? We talk about how these rules have to be reasonable, and what's the justification for the rules. Well, if we don't do anything about it, we're going to see a spike in our bills, which is going to be an increase in the assessments for everyone. So if we make this rule, again, this assumes, for your question, that you have the authority to create a rule that governs someone's unit. But assuming that you do, then I absolutely think you could pass a rule, and it would pass that smell test of whether it's reasonable, because we're looking out for the protection of the whole community, trying to avoid that increased cost in that usage. Now going back to, before I get into the fair housing, let me go back to the question that was asked earlier about the co-op. This is from Patricia, who says the co-op had no restrictions about smoking in or around enclosed patios. Now they're trying to pass where they want members to smoke cigarettes in the Ramada area by the pool. Can they do that? Now, co-ops can be a little different. You're still going to have your documents and what the co-op board's allowed to do, what the authority is. But let's just say that this was, just for discussion's sake here, and kind of the more common scenario, because we don't have a lot of co-ops in Arizona. But whether it's a co-op or maybe it's a condo that says we're going to try to address the smoking that's taking place on the patios. As I mentioned before, those patios are the limited common elements that the owner gets that exclusive use, but they're still subject to association rules in most cases. So I do think that there's a pretty good argument that the association could prohibit smoking in certain areas and direct that smoking take place in other areas. Now, I believe I saw your question maybe ahead of this presentation, and the concern was raised that they want us to smoke in an area by the pool where there's kids around the pool. And is that really a better solution? And it may not be. And that could go to the issue of whether the rule is reasonable. It's like, the basis of it is for the protection of owners and the smell getting into others' units. But now you're telling us that we can only smoke where there's going to be a bunch of people around at the pool area, which doesn't make any sense. So I think they may have the authority to do what you're suggesting or what you're saying is happening. They might have that authority, but there might be a question as to whether that rule is reasonable based on the way you're describing it. I should probably have asked you who the association is. I don't think I represent them, but just generally speaking, again, this isn't any sort of legal advice, but generally speaking, there may be something to look at there to kind of question whether what they're doing is reasonable as a rule. So, so back to the fair housing concern that I think can come up here. As you probably know, the fair housing rules are in place to protect certain classes of people. And the most common one that we see in associations involves disabilities. And the kind of the problem that associations run into is that the word disability has such a broad definition under the fair housing laws, both federal and state, that I bet a majority of us on the call today could probably think of something that we're going through that might qualify for a disability under the way it's defined. It's essentially a physical or mental condition or impairment that substantially impacts a major life activity. That's the way they define it. So it's very broad. It could encompass a lot of things. And if someone is disabled, you could have a situation where someone, I've actually read some cases about this and just some articles that it can kind of cut both ways here. You could have an owner that comes to the board and says, hey, you have a rule now that says I can't smoke marijuana in my unit or on my balcony or anywhere. I'm disabled. I need to be able to smoke marijuana as a reasonable accommodation. And I'm sure you've heard that phrase thrown out too, that if there's a rule in place and someone is disabled, they can ask the association for a reasonable accommodation or an exception to that rule, that the rule is preventing them from enjoying their property because of their disability. And the accommodation will allow them to continue to enjoy that property. So you see it very commonly with dogs, emotional support animals that allow that in a place where pets aren't allowed, or there's a weight limit, where they're allowed to have that animal so that they can enjoy their property with their disability. So just to jump back real quick with the question about the smoking by the patio, the question says that she has grandchildren that swim a lot and she doesn't smoke, and now they want my grandchildren to see other shareholders smoking cigarettes and marijuana. Is that reasonable? Again, I think there's certainly an argument that would not be reasonable if it's in close proximity to where other people are going to be. Again, as I mentioned in the beginning of this, some of these questions are really hard to give a good answer for you, because I think there's a lot of things that go into this. What is their authority? Kind of what's the distance between where they're going to be in the pool? I think there's a lot of factors that would have to be looked at by someone probably outside of the setting of this class to give you a better answer. But it sounds like there's certainly might be something there might be something there that is worth looking into further. It doesn't quite smell right. no pun intended, but I'll just leave it at that if that's all right. And we could try to talk offline if you want, but with the fair housing issue, the reasonable accommodations, let me just give you the quick overview of that. The key to a fair housing claim, one is the association doesn't have to do anything until a request has been made. If you know someone's disabled, you don't have to be proactive and do something. Two is that, and more importantly, is that the request that's being made has to be necessary and reasonable to accommodate the person's disability. Now, for something to be necessary, they just have to show that they have this disability and there's this connection, this nexus between their disability and what they're requesting. You know, seeing eye dog, someone's blind. But that does, I'll mention that in a minute to kind of come back to that. But then reasonable, if the request causes the association to have to incur additional expenses or fundamentally alters the operation of the association, then that's not going to be a reasonable request. And that could be denied. So that's the analysis that has to take place every time that one of these requests comes up. So from what I've read in the cases, there have been there's two different scenarios I've seen when it comes to marijuana. One, you have a homeowner who is disabled. We'll check that box. And like I was mentioning before, comes to the association and says, hey, you don't allow me to smoke marijuana under your rules or under your CC&Rs. I want an accommodation to be allowed to smoke marijuana to accommodate my disability. So if you look at that case in particular, the person is disabled, so we check that box. Smoking marijuana is going to accommodate, assuming they can prove that they really need to be able to smoke medical marijuana to accommodate whatever they're going through, then that might check that box as well. But then, so the necessity box, the real question though comes down to the reasonableness of it. And because federal law still prohibits marijuana smoking, no one is allowed to benefit from the fair housing laws if what they are doing violates the law. They don't get that protection of fair housing if what they're doing is a violation. So that would stop that request in its tracks right there. There's also potentially the argument that if you were to allow this to happen, we have this ban in place. To allow that to happen now, it's just going to open up this can of worms of everyone complaining. And I think you could argue that would be a fundamental alteration to your operations as an association. So I think there would be ways to counteract a request for an accommodation to be allowed to smoke medical marijuana in the event that you have a ban in place that says you can't do it. The other scenario that I actually read an interesting case out of Michigan. I couldn't find any in Arizona, but there was a case in Michigan where it was kind of the opposite, where you have I'm just going to try to go through the facts here. You have two homeowners living in a condominium, one above the other. The tenant, it was actually a tenant in the unit below, was a chain smoker, you know, for whatever you want to call it, where they smoked all the time. And just looking at a comment here. They smoked all the time, and it constantly went into the unit above. The person that lived above suffered from asthma and claims that the smoke and the smell was exacerbating the asthma, making it hard to breathe, really hurting her health, and made requests for the association to do something about it. The association actually came in and offered to install at their own expense an air filtration system into the unit below so that it would filter the air as it went out, you know, as it was kind of sucked out of the unit, and install that. That didn't really help. And so it got so bad, and there were you know, an altercation between the owners. You know, it got really bad. Police were called, but eventually this owner above filed suit. And when she filed the lawsuit, she sued the owner below, the tenants, but she also sued the management company, and she sued the association for failing to enforce its documents, because there was a this whole nuisance thing. But she tried to argue that, or even before the lawsuit, she tried to make a request for an accommodation. She called it that, saying that her disability was the asthma that she suffered from, and your accommodation needs to be that you stop her from smoking. And they were serious with this. They filed this in court, that the accommodation needs to be that you stop her from smoking so that I can enjoy my property. And that argument didn't go very far with the court as far as the accommodation was concerned, because there were kind of the reasonableness aspect of it, what wasn't met. She wasn't able to prove, she didn't have enough evidence to show that there was a connection, that she really had a disability. And there were some other arguments that she also had made, but it just highlights that someone could also try to argue kind of the other side of it, that I'm disabled, you're allowing this smoking to take place, you need to do something about it, and I want protection under the fair housing laws to accommodate my disability because of this presence of marijuana smoke or whatever it is that now exists in the community. And so I think associations need to be aware of that, that these fair housing arguments could come up in light of the medical marijuana that seems to be everywhere now, and people's use of it, but also the fair housing and the aspect of marijuana smoke and maybe smoking in general, that might impact someone who has this health condition that is now exacerbated by the presence of smoke. So just mention that I haven't had to deal with one of those cases yet in my office for an association in here in Arizona, but I think it's something that at some point will show up, and associations may have to face that. So now with that, so I guess in conclusion, and I know we're not going to be to the 3 hours, and hopefully we'll have some more questions. But I just want to mention that, as one of the comments was made, that some of this might not be anything new to any of you. You're already doing something to enforce particular activity in your communities, and that's great. Continue to do it. And you may just have to broaden the scope of it to include marijuana. You may need to change your rules to make a reference to marijuana smoke, or to, if you're already restricting smoking, then maybe you need to broaden the scope of your rules to deal with cannabis use in general. We don't want anyone using marijuana in any form on our common area. We don't want anyone in the pool area with marijuana edibles or any other form of cannabis in the pool area or any other common area. I would recommend that you look at doing that, just to make sure it's covered, and that everyone's on notice that is now a rule that's in place for our common property. And then as far as units are concerned, we've talked about this nuisance requirement and whether or not you can meet that or not. But let me talk about, first I want to talk about planned communities. And I didn't mention this as much in the details of it. I think trying to enforce any sort of smoking issue, whether it's marijuana or cigarettes, in a planned community setting is very tough. Most documents are not going to make any mention. In fact, I can't even think of any community documents I've seen for planned communities that deal with smoking, that have a reference in the CC&Rs to smoking. And so you're probably going to have that first hurdle, that it's not in your documents. And then the second one, though, would be how can we go about regulating an owner's use of their property? Even if you have the rulemaking authority to do it, I think you're going to have a hard time convincing a court that your rule is reasonable if you try to tell someone in their own house that they are not permitted to use marijuana, especially now that it's legal as long as they're complying with what we talked about from Proposition 207. I really don't think you're going to be able to do that with your rules for the inside of someone's house. And then even if you could, enforcing this type of restriction is going to be tough. I'll use my own community as an example. I have my wife has one of the more sensitive noses that I've ever met, and is very sensitive to the smell of marijuana. She does not like it at all. And we have a neighbor somewhere that usually between the hours of 7 and 9, either from inside of his house or maybe out on the back patio, partakes in marijuana and smokes it to where you can smell it. The problem is I have no idea where it's coming from. We've gone out and walked around, see if we can see anything. And we have two communities. I'm up against my back wall neighbors, another community outside of my association. We think it's the house in the other association, but I have no idea. And I'm not going to invest that much effort in trying to find out who it is, because what can I do? But I think that highlights one of the problems that associations will face is in trying to enforce this. If they're doing it inside of their house, you can't smell it, you can't see it. And then even if it is bothering a neighbor, does it rise to the level of a nuisance where you could even take action as an association? So I think with planned communities, I think you certainly want to look at regulating activity in your common area. I think you have all kinds of reasons to do that, but you probably need to be a little more cautious and may not be able to do anything beyond what's in your CC&Rs as it applies to their lots and their property.